Good evening. Thank you for joining us. On behalf of Conservation Law Center, my name is Katie Beck, and I'm here to welcome you to Talking Conservation, a public lecture series that explores the ideas, people, and legal frameworks that shape the future of land, water, wildlife, and healthy communities. We're especially grateful that you're here tonight for the first official lecture of this series. It's exciting to launch what we hope will become a regular forum for thoughtful conversations about conservation law and policy in Indiana and across the Midwest. The topic of tonight's lecture, the legal toolkit for land conservation, is at the heart of Conservation Law Center's work. Our organization partners with land trusts, community groups, and conservation organizations across Indiana and the Midwest to help translate conservation goals into durable legal protections for land, water, and wildlife. The legal mechanisms that make conservation possible are often invisible to the public, but they're essential to ensuring that conservation outcomes endure for generations. Tonight's talk will dive into those legal mechanisms, and we also have two excellent programs coming up later this year that I'd like to tell you about. So next month, on April 8th, we'll welcome Janet McCabe, the former Deputy Administrator of the U.S. Environmental Protection Agency, who will be speaking at the law school about federal environmental policy and state-level impacts. And then in October, we'll host Paul Labovitz, the recently retired superintendent of the Indiana Dunes National Park, to talk about protecting public access to Indiana's Lake Michigan shoreline. You can learn more about this lecture series and register for upcoming talks at www.talkingconservation.org or by scanning the QR code on the flyer on your table. Okay, before we get started, I have just a couple of notes of housekeeping to go through. First, tonight's lecture has been approved for one Indiana CLE general credit, so if you're an attorney in the audience, please be sure to sign in on the CLE sheet at the front table. We'll submit your attendance after the event to ensure that you receive credit. And second, tonight's event is being filmed and photographed for publication on CLC's website as part of a new and growing educational resource library. So by remaining in the room, you consent to being recorded, and if you prefer not to appear on camera, please just let one of our team members know. And finally, I want to extend a heartfelt thank you to our series sponsor, the Duke Energy Foundation, whose support has made tonight's event possible. Now, to help introduce tonight's speaker, it's my pleasure to turn things over to Christian Freitag, a man whom I'm sure many of you already know. Before joining CLC, Christian spent nearly 2 decades at Sycamore Land Trust in the role currently occupied by tonight's speaker. And now he is the executive director of the Conservation Law Center, and his work focuses on using the law to protect land, water, and wildlife in Indiana and beyond.
Thank you, Katie, and thank you everybody for coming. It's certainly nice to see so many familiar faces, mostly friendly faces too, I'd like to say, but louder? Okay, louder. I'd like to introduce Sycamore Land Trust's new executive director. Alex Sienkiewicz has spent more than a quarter century in various aspects of conservation work across the United States. Prior to being hired at Sycamore, he served as the Chief of Resource Stewardship and Science at Carlsbad Caverns National Park in southeast New Mexico, a UNESCO World Heritage Site, where he led a team of scientists, resource managers, and museum and curatorial professionals in managing the park's scientific research and resource stewardship portfolio. Prior to that, he was a district ranger for the million-acre Yellowstone Ranger District of the Custer-Gallatin National Forest. Earlier in his career, he was a presidential management fellow with the U.S. Forest Service in the D.C. headquarters. In 2018, he was awarded the Jim Posewitz Professional Conservationist Award for contributions to Montana and the greater Yellowstone ecosystem. Alex and his wife, Holly, have 3 children. He also hides this, but he's a lawyer. Too bad. I know we're all invested in Alex's success, nobody more so than me, and the continued success of Sycamore Land Trust. I know that's why we're all here. So please join me in giving Alex a warm welcome.
Thank you, sir. All right. Let's see. Good evening. I didn't plan on holding a microphone tonight, but I will make it work. So, as Christian said, my name is Alex Sienkiewicz. I'd like to thank the Conservation Law Center for hosting me tonight to share some thoughts with you folks. I'd also like to thank Christian, the Executive Director of CLC, as well as Katie, the Advancement Director. And I'd also like to thank my colleague, Susan Hayslip, for her editorial advice as I was working on this talk. I'm currently the Executive Director, as Christian said, of Sycamore Land Trust. We're based out of our headquarters, a beautiful mid-century home here on the east side of Bloomington. We're a nonprofit land trust whose mission is to preserve the beauty, health, and diversity of southern Indiana's natural landscape through strategic land conservation and environmental education. Our vision statement sees a southern Indiana with diverse and abundant habitat for native plants and animals, as well as clean air and water, working lands that are productive and sustainable, and people who embrace the connection between a healthy environment and our quality of life. All that said, any opinions I express tonight are mine alone and do not necessarily represent those of my employer. As a practical matter at Sycamore, we buy land outright as well as hold conservation easements on private land that ensures perpetual conservation values may remain on those lands. By way of education, I hold degrees in forestry, law, history, and public administration. For what it's worth, this is not an AI-generated talk. I don't know if it's a good thing or a bad thing, but I think I'm supposed to tell you that. So, as an overview, I will present some big ideas on land from thinkers I've recently read. I will discuss briefly some of the many reasons we conserve land. I will talk a bit about my public service experience and public lands background. I will distinguish between the public and private jurisdictions and emphasize that the land conservation toolkits differ for each jurisdiction. I will discuss the importance of clarity and precision in our language in land conservation work and planning. I'll discuss the basic conservation toolbox or toolkit for private lands, then I'll do the same for public lands. And I will next discuss the importance of relationships in conservation as the most important tool in any toolbox. That's my take-home theme tonight. Last, I will relate a story wherein ultimately relationships trumped money, power, and history for a public lands conservation win in Montana. So as a preface, I'd like to offer you folks some provocative thoughts as we get going. Feel free to challenge any of these thoughts or ideas or my assumptions at the conclusion of my talk. So let's start thinking about land conservation at the 30,000-foot level and gradually drill down into this conservation toolbox or toolkit topic. I enjoy the topics of land use and conservation, and so I'd like to share some thoughts from recent thinkers whose books I've read. In his recently published book, Land Power, Professor Michael Albertus notes that over the broad sweep of time and across the globe, that our lives today are determined by the choices that were made during past land use decisions and as a function of ownership patterns that we as a society have inherited. As every country's most valuable tangible asset, he notes, land and its uses and management seeps into every social, economic, and political layer of society. It lingers there even as the economy and society change. Professor Albertus notes further that land power is social power. Large landowners have long shaped the social order and sat atop the pyramid of social hierarchy, commanding respect and taking advantage of special access to exclusive organizations and social circles. Across the centuries, large landowners have ruled over their territorial domains and extracted rent, labor, and deference from legions of souls who have worked their lands both freely and in various forms of bondage. Land power is political too. The resources and status that influential landowners hold has enabled them to shape the founding of nations and governments the world over, including our own. Politicians use land policy as a valuable tool to garner political support and undercut their opponents. Property taxes, zoning, eminent domain, land grabs, land grants can be wielded by a society's winners against their foes. Economist magazine Wall Street editor Mike Bird, in his recent book, The Land Trap, likewise calls land the world's oldest asset. And he emphasizes that the link between banks, businesses, and land is a crucial and underappreciated element for understanding how a modern economy works. In addition to Mr. Bird's thoughts, I would urge you to consider the role that institutions play in a land-based economy. For example, the rule of law, taxation systems, government enforcement of legal titles. The architect and writer Witold Rybczynski, in his fascinating book on real estate development, The Last Harvest, notes that from the beginning, America has been characterized by expansion and population growth. Accounting for macroeconomic undulations over the decades and centuries, I would agree wholeheartedly with Rybczynski that growth and development characterize our landscape here in America, generally speaking. So the last prefatory idea I want to share with you folks is the title of Chapter 7 in Land Power, Professor Albertus's book. Albertus declares, "The arc of history is long, but it tends toward development." I firmly agree with this contention, and that is part of the reason that I have dedicated my career to conservation of public and private lands and the ecosystems they support. All of this change, of course, has economic benefits, but it also has vast ecological and economic costs if one is accounting holistically and honestly. So with Albertus's and Bird's and Rybczynski's words and ideas as food for thought, I'd like us all to ponder the role that land plays in the lives of individuals and in the lives of nations. Albertus clearly articulates that land is power. And in the context of land, there are winners and losers. I would ask you to also ponder land uses in the United States of 2026. In addition to these big ideas I've shared from Professor Albertus and Mr. Bird and Mr. Rybczynski, I will also assert that not only is land the world's oldest tangible financial asset, but that land is the world's oldest conservation asset. Land is conservation. So I want to run through some quick reasons on why we conserve land. I've spent my career in the conservation of both public and private lands, and it's important to remember that we conserve land for many different reasons. So I'll touch briefly on some of those. We conserve land for quality of life and community reasons. We conserve land for ecological reasons related to air, water, soil, and ecosystems generally. We conserve land for individual species, wildlife, fish, and biodiversity. We conserve land for economic reasons, agricultural reasons, cultural reasons, recreational reasons, spiritual reasons, health and therapeutic reasons, reasons of scientific discovery and technological potential. And we conserve land because we should, because of its innate value. So we conserve land for ethical reasons. We also conserve land for intergenerational obligation, for a sense that we should preserve it for our progeny and for future generations. So to the topic today, the legal toolkit for land conservation. I will discuss both public land conservation and private land conservation. As a disclaimer, contrary to what Christian said, I am not, nor have I ever been, an attorney, but I have worked in and around conservation law and policy for several decades. As a public servant with federal agencies, including the U.S. Forest Service and the U.S. Park Service, I have interpreted applicable state and federal law. I've applied laws and spent some millions in public funds in fulfillment of the law, mostly on excellent outcomes most folks appreciate, like maintaining trails, restoring habitat, and supporting scientific inquiry. But I've also worked on more controversial mission goals, like the sustainable production of commodities, including saw timber from national forests. I've managed uses as disparate as federally designated wilderness areas, as well as cattle grazing allotments on public lands. I've had the pleasure of managing cattle grazing allotments within federally designated wilderness areas, and that's not really a pleasure. I have seen many a public lands debate and lawsuit, and this is all by way of saying that land conservation is complex, and it's subject to constant debate and litigation. In the federal public lands context, it's prudent to remember that executive branch agencies are creatures of law and subject to hundreds or perhaps thousands of laws passed by Congress. These laws address internal governance, for example, the Civil Service Reform Act of 1978, overarching agency missions, for example, the National Park Service Organic Act of 1916, the agency norms, habits, and mandates, for example, NIFMA, or the National Forest Management Act of 1976. And of course, some laws implicate conservation matters on private land, for example, the Clean Water Act or the Clean Air Act. And some laws funnel public funds to the conservation of private lands and the resources they hold. For example, the Land and Water Conservation Fund Act of 1965, or the Pittman-Robertson Wildlife Restoration Act of 1937. So the first question to consider is, what is the conservation context? Is the land that you're looking to conserve public or private? The legal toolkit for land conservation is going to vary depending on the answer to this question. The distinction exists because some conservation laws apply exclusively to government-managed lands, and some conservation laws apply exclusively to privately owned lands, while some law applies to both public and private land. Land conservation law also may occur at federal, state, and local levels. With regard to state law, there may be significant variation as between different states. Local ordinances, say addressing a city, county, township, town, village, can also vary as regards the exact same subject matter. So the take-home message here, as far as conservation work in a specific place, is consult those in the know. Who is your audience? What laws apply? What is the legal landscape? At a very basic level, who presently owns the land? In law school, you learn to consider basic questions of jurisdiction early and often. This is apropos to land conservation work. Ironically, while sorting out questions of legal jurisdiction as critical nuts and bolts policy issues in conservation, it has to be remembered that ecologically speaking, jurisdiction and political boundaries are merely human constructs. And where ecology and biological organisms are concerned, political boundaries and legal jurisdictions usually complicate and hinder the prospect of ecosystem protection and species diversity. For example, there is currently a policy proposal to extend the southern border wall through Big Bend National Park. Significant opposition to this proposal relates to ecological and species migration impacts that would occur as a function of this politically imposed boundary and its associated physical barrier. Essentially, the bears, the deer, the elk, the bighorn sheep, the mountain lions, and other species obviously don't abide by political boundaries. If isolated by walls marking political boundaries, there are implications, of course, for species survival and conservation. So in short, conservation of land and species must consider both political jurisdictions and ecological realities. A good example of conservation addressing both ecological and political boundaries are highway wildlife crossings, such as you see on the Salish Kootenai Reservation south of Glacier Park in Montana, if any of you have seen those. The next topic I want to address is clarity, precision, and context in our language and terminology. For many reasons, conservation requires that parties involved in contracts, agreements, policy, and lawmaking toward conservation ends be precise in their language and define operational terms well. This is true both in private lands as well as in the public lands context, where executive branch agencies are involved. In the vein of precise language, let's jump into some definitions. As regards the legal toolkit for land conservation, let's first define our terms so that we can have a common understanding. What is land conservation? A few internet searches give us a working definition that I think is reasonable. Land conservation is the practice of protecting natural land and restoring developed land to its natural state. This sounds like a good definition to me. That said, one could take a descriptor like natural and write dissertations about that one word's meanings. One could also spend a good deal of time dissecting the word restoration. I don't want to spend too much time on such semantic matters tonight, except to emphasize that in land conservation, like many other realms of discourse, words and context matter. For example, conserving natural land that has never been directly worked, developed, or manipulated by humans is, from a biological and ecological perspective, usually much more practical, affordable, and impactful than attempting to quote unquote restore land. When you restore land, you're restoring the native assemblage of organisms from micro to macro, once associated with land that has been developed or extensively manipulated by humans. So true restoration of ecosystems, where the native assemblage of plants and animals and microorganisms and insects and other life have been extirpated, is really not possible, at least not in the minute scale of human lifetimes. So if a group is crafting a conservation easement for the protection of a piece of land, it should invest significant time in clear definition of what desired future conditions look like. The theme here again being clarity, precision, and context, such that an ecologist would approve of the language and the documents at issue. In short, what I'm trying to get across is that if concepts like conservation and biodiversity are to be borne out in law and policy and easement language, we really need to get the definition of terms and the conservation outcomes right. Some of you may know Aldo Leopold, the writer, professor, conservationist. He famously wrote that an ecologist lives in a world of wounds because he or she is so keenly aware of the scars to the land and the ecological destruction fomented by humanity. I would also add that an ecologist lives in a world of spoiled movies, where, for example, in The Deer Hunter, supposedly set in Pennsylvania, Robert De Niro is filmed chasing a Roosevelt elk, not an eastern white-tailed deer, through the high peaks of the North Cascades in Washington state. In another movie spoiled for the ecologically minded, The Revenant, about Yellowstone mountain man Hugh Glass, Leonardo DiCaprio is portrayed roaming soggy cedar spruce forests somewhere hundreds of miles northwest of where Hugh Glass led his actual life in the dry lodgepole pine forests of the Yellowstone country. I offer these two examples of movies that were ruined for me to add emphasis to the idea that in conservation planning, we must strive for precision in our language, properly defining key terms and thinking not just legally, but ecologically. So, since coming to Sycamore Land Trust, I've been candid with colleagues and friends about my preference to conserve land and habitat here in Indiana and the Midwest at a greater pace and scale than is occurring at present. I confess to what I would call a protect or a put away acres philosophy as my default desire. I generally view all land as subject to development unless it is conserved. As Professor Albertus says in his book, the arc of history is long, but it tends toward development. All that said, we humans will not be able to buy our way out of the habitat destruction crisis and species loss. There is not enough money in the entire federal treasury to buy outright all of the lands that should be protected in order to conserve enough habitat such that we could bring species extinction down to zero. In short, buying land for conservation can be effective, but it is far and away the most expensive land conservation tool. In order to conserve land and species at scale, we have to explore all manner of conservation tools. These include fee simple or buying land outright purchase, conservation easements, conservation leases, and creative voluntary measures as well. So the first tool I want to address for private land conservation is fee simple purchase or buying land outright, as I mentioned. When I first took property law in law school, I don't consider myself a lawyer, but I did go to law school. I learned the bundle of sticks or bundle of rights theory of property. And so the theory holds, or the metaphor holds, that there are many separate property rights associated with any given piece of land. And generally speaking, if one holds the entire bundle of sticks, it represents whole or undiminished interest in the subject land and all of its resources. If the owner then sells mineral rights or timber rights, say, or other interests or sticks, the owner has severed property interests or diminished the bundle of sticks. If, for example, a landowner sells or donates the development rights to her property to be held by a land trust, she has in essence gotten rid of part of her property rights bundle, either for philanthropic or profit-based purposes. My point with a quick overview is to mention that fee simple ownership, that is to say owning the full bundle of sticks, is ideal if conservation and protection of habitat in perpetuity is the objective. However, where conservation and public access is the objective, fee title ownership of land takes management. This is a forever prospect. It's a forever prospect as regards costs, demands, infrastructure upkeep, liability management. With the exception of federal and state government entities, very few entities or individuals are wealthy enough to own and manage conservation lands at the scale of hundreds of thousands or millions of acres. A few notable exceptions include the billionaire conservationist Ted Turner, the American Prairie Reserve, an NGO in northern Montana, and perhaps the Nature Conservancy. And notably, the pressure for such entities to develop their conservation properties to generate revenue streams is significant. Last week at a Sycamore Land Trust event, a member asked if buying conservation lands and transferring them to the government land management agencies was a safe prospect or a good conservation investment. This question stumped me for a moment as I pondered the stability of our government. In short, what I said was that while no institution in the world is fail-safe, I would say that the federal land management agencies, as holders of conservation lands, are a good bet, quote unquote, particularly with bipartisan support for a given project, which is not uncommon in the world of public lands. So the second tool I want to talk about for private land conservation are conservation easements, or you might hear them called CEs. The Northeast Regional Land Trust notes that the first land trust was established in the United States more than a century ago. And all told, land trusts have protected more than 61 million acres in the US. Most land trusts hold conservation easements as their primary conservation tool. A conservation easement is a voluntary legal agreement between parties where certain uses on a particular piece of land are restricted or limited. The objective of a CE is to protect certain values, for example, wildlife habitat, wetlands, agriculture, forest cover, and so on. A landowner typically donates or sells these rights to a land trust or government agency, which then holds the easement. Conservation easement restrictions are part of a property's deed and thus run with the land. They're perpetual. As I discussed earlier, under the bundle of sticks theory, a standard conservation easement might prevent the landowner and future landowners from various types of development, say mineral extraction, timber harvest, road building. Land subject to conservation easements can be subsequently sold or deeded to heirs. In my experience, conservation easements are incredibly customizable. For example, I've worked with landowners that sold or donated conservation easements but retained interests in that land, such as hiking or hunting rights. Or, for example, an easement might limit future development to a single dwelling so as to appeal to a conservation-oriented buyer, or allow an heir to remain on the land. A conservation easement could also allow for the development of a single variety, such as timber management, agricultural use, or other such uses. Notably, however, the holder of a conservation easement, in order to meet relevant law, policy, and certification requirements for a land trust, excuse me, notably, however, a conservation easement, in order to meet relevant law, policy, or certification requires, has to consider carefully what kind of custom or granular requests or granular nuances it is capable of managing as part of that easement. For example, as a longtime land manager, I'm acutely aware of what conservation easement language may or may not be sustainable from a management and enforcement perspective. So there are a number of general requirements for conservation easements. They need to abide by IRS law and requirements. They need to be in writing. They need to be perpetual, and they need to be recorded with the local authorities, held by a qualified organization. And like I said, that's typically a land trust, 501c3, or a government agency. So the last tool I want to talk about for private lands are conservation leases. And leases are exactly what they sound like. They're basically a contract for temporary use of a land for conservation purposes. Some might ask, why bother with a conservation lease? Why bother with temporary protection? And I think this is a fair question. I recently had a discussion with a colleague at Sycamore Land Trust, and she talked about how the federal NRCS conservation reserve programs through the Department of Agriculture and state-funded leases often resulted in long-term goodwill and relationships. And this, in turn, could result in a landowner's decision to pursue permanent conservation outcomes. Again, relationships. So in short, leases are, as I like to say, better than nothing. So now let's jump over to the public lands jurisdiction. For the Public Lands Conservation Toolkit, we think generally about federal and state level public lands. They're usually managed by government agencies, and we're typically talking about lands such as national forests, national parks, and Bureau of Land Management, or BLM lands. The management of these lands, I would argue, is fairly complex, though certain flavors of public land, for example, state trust lands, have a narrower and perhaps simpler mandate than do many of the flavors of federal land. Many of our federal lands tend to be multiple use lands and thus subject to dozens or hundreds or perhaps thousands of different laws. There are year-long courses on public land law, and we can only scratch the surface tonight. But suffice it to say that agency missions and the high-level land conservation outcomes for our public lands have been legislated by Congress, and the nuances have been determined and variously refined by common law over the decades since the passage of the laws. There has been a new wrinkle in federal public lands management of late with regard to the 1996 Congressional Review Act. The 1996 Congressional Review Act has historically been used infrequently, but in 2025, it was used more than 20 times, according to Harvard's Environmental and Energy Law program. The CRA allows Congress to veto federal agency rules and act immune to judicial review in its actions under the CRA. I would argue that this represents Congress's delving into executive agency management issues and missions at a very micro level. The CRA also prevents agencies from reenacting similar laws in the future. So this law, in conjunction with recent administrative rollbacks by the Supreme Court, translate to a significant loss of discretion for the federal land management agencies, and I would argue for all federal agencies. In 2025, for example, Congress used CRA to undo four Department of Interior land management plans. It also undid a number of other environmentally protective rules, such as California's ability to set its own air standards under the Clean Air Act. At the moment, the current Congress is using CRA to remove a mineral withdrawal in the Boundary Waters watershed in Minnesota. It is also working to undo protection under the CRA of the Grand Staircase Escalante National Monument in Utah by nullifying its current land management plan. So I mention all this only to say that the landscape for federal public land management and conservation is indeed always changing. As far as conservation on public lands, our tools as citizens are relationships with federal land managers. Thanks for coming tonight, Mike. So elected officials at all levels of government, industries, community groups, and so on. Closely related, our conservation tools are accountability under existing and applicable law, as well as working to craft new law that helps conserve federal lands. So the key message I'd like to convey is that our public lands cannot be managed other than the law prescribes, and ultimately, statutory and common law together tell us how to manage our national public lands. One of the last themes I want to hit on is something I've mentioned already. It's the importance of relationship building in both private and public lands conservation. Not to be overlooked, the basic principle for land conservation that I'd like to emphasize for both jurisdictional contexts is relationships. With mutual communication, understanding of individual and organizational positions and interests, and hopefully some hard-earned rapport and goodwill, conservation-minded organizations and individuals, landowners and land managers, and interested business and government entities can work together to conserve land and ecosystems where possible. And where conservation outcomes are not possible, relationships, ongoing communication, and relationships and ongoing communication may conserve future opportunities. All that said, relationship building in personal and professional contexts is arguably more challenging than it's ever been in the history of humanity. NYU professor Scott Galloway argues that in the modern context of the digital age, the mere attention of individuals, entities, and institutions is among the most scarce resources. He calls this digital scarcity. So more so than ever, our entire society exists in what Galloway refers to as the attention economy. The statistics surrounding humanity's screen time are startling. On average, Americans spend more than 7 hours a day looking at screens. America is more diverse, digitized, and complex than it's ever been. These circumstances are deterrents to meaningful, productive relationships. Conservationists and anyone else who cares about ecosystems, economies, and communities must redouble investment in meaningful personal relationships. This is especially true in conservation. So I'm going to close out tonight with a little personal story. It relates to this theme of relationships in land conservation. Blocked access to public conservation lands. When long-standing, legal, taxpayer-funded public access to public land is blocked, oftentimes illegal roads and trails are pioneered on public lands by those blocking access. Noxious weeds are spread, timber is stolen, wildlife is poached. When legal access is blocked, illegal cabins and structures tend to appear on public ground. Addressing such issues is complicated and diverts scarce public land management resources. But most importantly, generations of people miss the chance to explore their public lands and to become complete Americans, exercising their public land property rights. De facto privatization of public lands is a massive, unaccounted for, tax-free taking from the US citizens. It is a theft from the nation. This is a wicked problem that does not get discussed enough. The Theodore Roosevelt Conservation Partnership notes that 16.43 million acres of your public land in 22 states are inaccessible. I would argue that through de facto privatization and unchallenged access blocking, these numbers are likely growing. In my decades of stewarding public lands, I encountered numerous wealthy, powerful individuals and entities working hard and working quietly to privatize national forest and national park lands, particularly in places like Colorado, Idaho, and Montana. Sometimes these folks were Wall Street tycoons, but just as often, they were longtime families that decided they wanted to prevent Americans from getting to their national forests. These privatizing landowners often wanted to keep the elk and the trout and the resources to claim for themselves. And just as often, they would sell these resources for profit. This would usually take the form of gating or running barbed wire across a long-standing, taxpayer-maintained road or trail into the national forest. Noted as official access points for decades on government maps and maintained by federal land management agencies, these traveled ways crossed private land to arrive at public land. These blockades were typically accompanied by signs that said things like, "No public access, enforced by Smith and Wesson," or "Smile, you're on camera." The access blockers, by preventing public use where legal histories and deed documents may have been blurry, or even when documentation was very clear, were able to stop all public hiking, hunting, and angling when government and citizens did not push back, for all intents and purposes, making magnificent mountain lakes and rivers owned by all Americans private recreational paradises. Prior to the forcible theft, long histories of continuous, publicly funded access had occurred for decades or centuries at such access points. Simultaneously, nearly all those people blocking historic official government access points held coveted permits to graze cattle on national forest lands. These grazing rights essentially came at little or no cost, and those blocking access also held heavily subsidized outfitting and guiding permits to sell hunts for trophy elk, deer, mountain sheep, and other sought-after quarry. They paid very little for these permits and often sold a single elk hunt for $6,000 or $8,000. In short, our public lands and wildlife out west face a wholesale privatization effort. However, I want to tell a more uplifting story. The story I want to tell is about how one such situation got resolved, and I relate this story to emphasize that, again, relationships are the most powerful tool in achieving conservation outcomes. When I landed in southwest Montana as a district ranger or accountable officer for the million-acre Yellowstone district of the Custer-Gallatin Forest, north of Yellowstone Park, one of these forest access fights landed right in my lap. It was 2011. As I settled into my ranger station office in Livingston, Montana, I began to receive calls that would continue for 14 years. The calls were from frustrated citizens complaining that locked gates and barriers had gone up, preventing them from using roads and trails to get to their cherished national forest campgrounds, their hunting spots, their fishing holes, and high peaks. One of these unfortunate situations involved a gentleman, let's just call him Joe. Joe had purchased a ranch of some thousands of acres in a beautiful river valley in the northern Yellowstone country. Think Sound of Music. Above lush pastures and riparian lands and blue ribbon trout rivers stood snow-capped alpine peaks. Below the peaks were cerulean alpine lakes that fed streams and rivers replete with native cutthroat trout, eager to rise to a dry fly. In the valleys below the lakes roamed moose, mule deer, bear, lynx, wolverine, and other amazing critters. Copious elk herds grazed in alpine meadows, flanked by stringers of aspens and cottonwoods. I'm not exaggerating. This is what many of our public lands look like and what many of the coveted private ranchers in the northern Rockies join. When Joe, who was wealthy enough to employ many lawyers on his behalf, bought the ranch, one of his attorneys notified him that the centuries-old taxpayer-built and maintained Forest Service road that ran through the edge of Joe's ranch to the trout and the elk and the deer on the national forest did not have appropriate documentation in the county courthouse. Armed with this advice and the encouragement of lawyers that Joe paid handsomely for such advice, Joe and his ranch managers locked a gate across what we'll call Paradise Creek Road. The trout stream's peaks and elk on public lands had, for all intents and purposes, been privatized by Joe and his attorneys. When I first dived into the case, I learned that Joe's attorneys in Billings were in ongoing communications with Department of Agriculture attorneys and Department of Justice attorneys in Missoula and DC. There had been a lawsuit prodding the Forest Service to defend historic access to the National Forest, third-party amicus briefs, and the situation was nasty and complicated. The parties had, after some years of jousting, settled into a tenuous agreement where the gate across Paradise Creek Road would stay open for a decade under the current court-ordered agreement. But if resolution could not be reached, all bets were off, and the situation would revert to its untenable past. I arrived to my post about year 9 of this agreement, with new access disputes arising on all compass points around Paradise Creek with regularity. I began participating in the negotiations surrounding Paradise Creek while playing whack-a-mole with all the other land disputes that were arising on the district I managed. In the Paradise Creek negotiations, I noticed immediately the enmity between my boss and Joe's lawyers and Joe himself. It was palpable. It was painful to observe. I did not like that Joe had blocked a centuries-old public access to begin with, but my boss suffered her own foibles. She was excessively arrogant and wore her emotions on her sleeve. She tended to look at this and other situations as a zero-sum game, and for her it was about winning. She spoke frequently of her quote-unquote legacy. This was not the attitude of a humble public servant. In fact, my boss, I later learned, had published an op-ed slamming Joe in the middle of the ongoing negotiations as an out-of-town tycoon carpetbagger, thus exhibiting what I consider to be imprudent tactics, and on its face a behavior that only reduced the likelihood of a solution, a compromise, or a public win. My boss, I would say, was all ego, and thus she was never going to find common ground with Joe. On regular conference calls, as the local on-the-ground line officer, I slowly interjected a different tone into the conversations. I emphasized that I respected Joe's perspective, and I did, and that while our positions on the matter were different, I respected him as a human and as a property owner and a neighbor. I bucked the approach my boss took by inviting Joe out to coffee whenever he might be around. Joe lived in California. My olive branches on conference calls were ignored by Joe and his attorneys. My boss arrogantly suggested I was naive and mocked my efforts to build trust with Joe. Joe's lead attorney, as he was getting paid to do, mocked me as well and sent me nasty emails. I did have one colleague, however, an old civil engineer who managed the forest road and trail system, who was intrigued by my approach. He started to replicate my entreaties and adopted my conciliatory and collaborative attitude. My first year on the job was also the last year of the mandated negotiations. Time passed, and Joe and my boss and the government attorneys had made little progress. I suspected all of this was headed back to court. But what pained me most was that all the little kids in southwest Montana, kids from cities like Billings and Helena, kids from the Indian reservations, and small town kids were all about to lose access to the place they hunted, the place they hiked, the place they fished, to the place they built family bonds and built a land ethic, as Aldo Leopold called our relationship with nature. Joe had his ranch, a beautiful private ranch, but for all those kids from Billings, Montana to Bayonne, New Jersey, the National Forest is their ranch. It's the only ranch they might ever own. One Friday night late, I received an email on my BlackBerry. Remember BlackBerries? It was Joe. I will be in Livingston tomorrow, he said. We had coffee the next day. Now, Joe truly is a tycoon, but I, of course, insisted on paying for Joe's coffee. We discussed family and work. I asked about his life and his kids. I asked him about being an investment banker. I asked Joe about his helicopter. I asked about his ranch critters and his green alfalfa pastures. The approach is not rocket science, but I was sincere. I did want to reach a resolution. I told Joe I wanted an outcome where he could at least be satisfied, if not happy, and one whereby kids from Billings could go elk hunting with their dads and fill their family freezer for the winter. I didn't overdo it, but I looked for every opportunity to affirm Joe's humanity. Not only did I do this in person, I did this with Joe's attorneys. I did this in internal meetings when my boss was slamming Joe and spreading ill will among my colleagues in a sort of kill piggy, Lord of the Flies mob mentality. As it became known that I started to make progress building trust with Joe, my boss came to resent my success. I treated her the same way I treated Joe, with respect. It wasn't always easy, but it was the right thing to do. I put my ego down because that was the best path to conservation outcomes. Some months later, I received a Christmas card from Joe. Some months after that, Joe told me he was going to donate a clear easement to the public and would like to build and pay for a new section of road that would minimize his line of sight from his lodge house to visitors accessing the National Forest. I was all ears, I told him. Sometime later, Joe and my engineer colleague and I would meet out on the edge of the National Forest to lay out a new public access road. The conversation was easy as we had built trust over some years now of working together through difficult problems while treating each other with respect and dignity. At one point, Joe, who had, as they say, everything a person could want in life, said to us, "You know, I don't like your colleagues. There is no way I would be doing this if you two were not involved." So what had happened? How did we find success? I don't want you to think that I am taking credit for this win. Joe is a highly intelligent man, and his calculus was complicated. It included his reputation, his business, the prospect of endless lawsuits, a stubborn district ranger who thought first of getting kids to their public lands and of not a lot else. Nonetheless, I tell myself that the efforts of a few of us to treat Joe with dignity, to put our egos down, and to solve problems with humanity and respect did help resolve this wicked dispute. The land conservation outcomes will be untold as generations of Americans once again can access the only ranch that most of them will ever own. And with that, I'll conclude by again emphasizing that relationships are the most important tool in any land conservation toolbox. Thank you. Thank you.
So we do have some time for questions if anybody would like to ask Alex anything while we're here.
You can ask a question, come up here to speak into the microphone, or ask out there and we'll repeat it into the microphone, so don't be shy. And it can be about his talk tonight or anything else you'd like to know, since he is, as we all know, new to Bloomington. Yes?
So I was born in Bloomington. I've lived here most of my life. I have spent time in Montana. How in the world did you decide to move from there to Bloomington? And I love Bloomington.
Yeah. What's your name?
Jim Wells.
Yeah, thanks, Jim. That's a great question. I've gotten that question quite a bit. I grew up in the East, and my ancestral homestead on my mom's side was not too far away up the Ohio River in West Virginia, and so the hardwoods definitely feel like home to me. But I'm also someone, Jim, who I have a little bit of wanderlust. My wife and I are recently empty nesters, so have a little bit of flexibility. And, frankly, I was looking for something different than a federal government job after about 20 years. Last when I interviewed with Sycamore, I found the board and the staff just to be awesome people and to really just be good, kind people with a land ethic, and that sort of sealed it for me. But yeah, that's it in a nutshell.
I come from New England, and when we talk about personal things, I grew up with Lake Winnipesaukee, Prairie Beach, Cape Cod, where you cannot go to, you can drive through, but there's not one of you can go to any one of those lakes. There's not any, almost, if you want to go to a beach on Cape Cod, you have to go to a hotel, you have the land. When I came to Indiana, I was shocked to see Lake Monroe. Lake Monroe was just developing in 1966. And I was so proud to see the law stating no house was to be built 50 feet above water level. People had worked hard to keep that. Now I know developers have override a lot of that, but I know how hard it is to manage or keep land. And I've spent a lot of time out in Montana.
What's your name, sir?
Oh, Ed.
Ed. Yeah, thanks, Ed. So for those who didn't hear, Ed was talking about having come from New England and places that are dear to him, like Cape Cod and Lake Winnipesaukee, are essentially inaccessible for most people unless you rent a hotel room for beach access or you have a house on the shore. And I believe the CLC is doing a future talk on the public trust doctrine, which addresses that very issue and sort of the property rights that associate with tidal lands or the land underneath water. That goes all the way back to Roman law, I think. So thanks for bringing that topic up.
You're fortunate to have people like this doing it. Of course, when you go to Salem, which was developed in 16-something, they didn't think about that. Hey, excuse me.
Oh, that's wonderful. Thanks so much for sharing. Sir, is that Chris?
I was going to say, could you go into a little more in-depth about that awesome staff, but it feels a little bit like self-promotion. So
Yeah.
I'll ask a real question. What gives you hope, in the climate that we're facing, with, all the challenges? I don't need to go over them. I think this room knows the challenges we face. And since we're a lot of people here with Sycamore, with CLC, and like what can we do and what gives you hope for the future?
So that's Sycamore Land Trust Stewardship Director Chris Fox. He's a popular guy around here. Yeah, thanks for that question, Chris. I mean, what gives me hope? You know, as I get older and grayer and I meet younger people coming up behind in conservation, and not in conservation, but people who care, people who use their public lands, it lets me know that we're not alone, and there's a big conservation, and both in public and private lands, conservation community, and you know, we are constantly spreading the word and the experience that creates more people, more Americans who care. I think, Chris, in our own organization, I mean, if you think about even the number of people that our education director, Sage, touches, individual youth, teachers, schools. I think just, you know, as long as we have these places, people will be impacted by them and changed by them. I think the moment these places go away, then all is lost. And so I think as long as there are communities like people in this room conserving private land, protecting public conservation lands, I have hope. That gives me hope. What gives you hope?
I can't top that.
Okay.
That would be a great place to end.
It would be,
But
right?
I did want to ask, how safe do you think conservation easements are? When I see so many things being undone, then the tax benefits associated with easements, you fear that those will be gone after by those who don't approve.
It's Ellen, right? Hey, Ellen, neighbor. Yeah, that's a great question. I'm sort of tempted to give the mic to Christian on this one. I think, you know, look, it's sort of like the question that I tried to articulate in my talk about the person's like, hey, you know, is it safe to buy up conservation lands and give it to our federal land management agencies? And I mean, there's nothing in the world that's permanent. Governments can fall, agencies can fall. When I was young, like a lot of us, I grew up messing around on national forests and public beaches and everything else, national parks, and I never conceived or understood that those could go away. And then when I started to sort of peel the onion back and study the law and the policy, I was like, holy cow, this stuff could be taken away by the right Congress or the right administration. And so I would say for conservation easements, if you happen to be in a state and the right administration or legislature is adverse to certain laws, certainly that tool could be impacted. Christian, do you want to add anything?
If you give me the mic, you'll never get it back. They are always subject. I mean, ownership's 9/10 of the law, right? So it'd be safer to own it, but that's not always an option. So you want to save as much land as you can, you open up the whole toolbox. Conservation easements are one of the big tools there. They could take away the tax incentives with that, but they can't take away the property right. And when good lawyers write good conservation easement contracts, those will persist.
Thanks, Ellen.
Final question?
I'd like to say thank you to Tara, please.
Just an add-on, if the conservation easement goes away in 50 or 100 years, at least in that time period, you've protected it. Better than not protecting it.
Yeah.
Good point.
I haven't seen everybody in the room tonight, but I do want to point out that the first letter that got sent out to his neighbors and friends and colleagues to create Sycamore Land Trust was sent by Tom Zeller. Tom Zeller is here, sitting over in the corner. pointing out, Terry Marbach, who just spoke a second ago, was also a board member for Sycamore Land Trust for, maybe 30 years, or 20 plus years, I would say, for sure. He was both of those people were in the room when I got hired as executive director, and I owed them a debt of gratitude, but particularly Tom Zeller. It got cooked up in his brain, and that's the reason that you're all here tonight, so good job, Tom.
All right, can we have one last round of applause for Alex Sienkiewicz? Before we wrap up this evening, I have a couple final notes. First, we're grateful for the insights that Alex brought to this conversation, for the work he continues to do to advance conservation. As a small token of our appreciation, we have a gift for you on behalf of the Conservation Law Center. Andrea will give it to you since I forgot. Thank you. As a new Hoosier, we got him a nice book about Indiana's state parks so he can begin exploring. Go Indiana, exactly. Second, we value all of your feedback on tonight's event. So in the next day or two, I'll be sending around an email with a brief post-event survey. Your input will help us improve this lecture series and shape future programs. I have a small incentive as well for that. So everyone who completes this survey will be entered into a drawing for $25 to JL Waters, a local favorite outdoor retailer. So please do take a look out for that email. And we have a small thank you just for being here tonight. So 2 of you are sitting in lucky seats. We have Conservation Law Center stickers underneath your seats. So now becomes the fun shuffle to bend over and look under your seat. If you do have a sticker, we've got a nice little CLC hat for you. So come find one of us and we will get you your prize. And thank you again for attending. So finally, if you enjoyed tonight's program and would like to support the work of the Conservation Law Center, we invite you to consider making a donation. You can donate online by scanning the QR code on the flyer on your table, or if you prefer, you can use one of the donation envelopes available at the entrance table as you leave this evening. We are a 501c3 nonprofit. We are supported by donations from people like you, so thank you for considering. And thanks for being a part of the launch of Talking Conservation. We hope to see you at our next event in April, and now is the time that we'd like to have you all stick around and create that community that we all agree is so precious to the conservation movement. Spend some time finishing the food, have another beer, mingle with your new friends and colleagues, and thank you again for joining us.